Hello everybody, this is Jacob Culliton from Leonis Law at leonislawllc.com, and today I'm here to talk about appearing in writing. Never again personally going to the justice or traffic court as a result of receiving a citation or a traffic ticket issued by a peace officer. Now if you haven't already, I strongly recommend that you watch my previous video titled Judge Admits Traffic Tickets / Citations Are Not Actual Charges. By watching that video, you will gain a solid understanding of why you never want to personally go to the courthouse to appear as a result of receiving a traffic ticket or a citation issued by a peace officer. So if you've watched that video and you understand why, now we're going to talk about the appearance in writing itself. As stated in the last video, each state is different. For instance, in Arizona, traffic offenses are civil. In Utah, traffic offenses are criminal. They are misdemeanors here in Utah, and each state is different. Each state has its own rules of criminal and civil procedure made pursuant to their state constitution, and you need to know those rules so that you can properly enforce your rights inside the courtroom or when you're appearing in writing. And with that being said, I'm going to explain how you would appear in writing as a result of receiving a traffic ticket or citation issued by a peace officer. Now, what people don't understand is that any pleading constitutes an appearance. You can appear in person, by counsel, or in writing. And anything you file with the court constitutes an appearance. So what you would do is you would get a court form. You can create it yourself. You would have your name and mailing address on the top upper hand left corner. You don't need to provide a phone number. You don't need to provide an email. That's none of their business. If they want to stay in contact with you, you want them to write you so you have a record of everything. And you don't need to consent to them having your email and phone number. And if they ask for your email and phone number, you can say, I only consent to communication through the mail so I have record of everything that is said and done. And they'll accept that. And with that being said, now that you have your contact information, underneath that you would put the name of the justice or traffic court. Under that you'd have the court address, and then under that you would have the court caption heading, the alleged cause. You would have a citation number, the complainant, the police officer's name versus your name, the accused. There is no plaintiff, there is no defendant, there is no case number because there is no actual case, because there are no actual charges. Like I said, you'll learn all that in my previous video. And so now you put underneath that the actual appearance in writing itself. Now comes the accused, John Doe Smith, sui juris, in propria persona, appearing not generally but specially to declare as follows. Now that sounds very complex, but it's actually very simple. Let me explain. Sui juris means of one's own right. In propria persona simply means in one's own person, not being represented by an attorney. They are Latin phrases. Appearing specially, not generally, means this is not a general appearance because that would mean I'm consenting to jurisdiction. This is a special appearance. I do not consent to jurisdiction. Then you would cite the law that traffic tickets and citations are not actual charges in your state. Now I cited that law for Utah under the Utah Code in my last video. Like I said, each state is different. And then you would cite the Utah or your state's rules of criminal or civil procedure enforcing those rights. And so now they have two options. One, they can say, well, this person knows their rights. It's not worth going after them. It's only a $90 ticket. We're not going to make any profit, and you won't hear from them again. However, if the fine amount that they think they can get out of you is large enough, or if they don't like the fact that you are exercising your rights to resist them and they don't want to encourage that kind of behavior, then they will come after you. They will file actual charges and get it approved by the judge, and then the court clerk will send a copy of the charges with the summons to your house. So what do you do at this point? Well, at this point you would simply appear in writing again. However, you would take the case number and the plaintiff's name and you, the defendant, off of the actual charges and put that in your next appearance in writing. So you'd have a case number, plaintiff versus defendant. You would appear the same way. The only difference is you would not put appearing specially, not generally, because now they have jurisdiction, now they have actual charges. Unless you want to challenge jurisdiction for some other unrelated reason, then you may do so. And then you would simply say, I hereby enter a plea of not guilty. And then you would mail that in. I always recommend certified mail. So now you have appeared to the arraignment. And now they will send you a notice of pretrial conference to prepare to go to trial. Now, if you're looking to get a plea in abeyance so this does not go on your record, then yeah, I recommend that you go to the pretrial conference and that you sit down with the prosecutor and you negotiate your plea in abeyance. That's the only reason most people plead not guilty. Most people don't really want to fight it all the way. They just want to make sure it doesn't go on your record. However, if you do want to fight it all the way, there is a way to appear in writing to the pretrial and even to the trial itself, and then you can appeal it to the higher court where you have a better chance of winning if you appear in person there. And I will cite the Utah Rules of Criminal Procedure. Like I said, every state it's the same. It's just a different rule and a different rule number. Each state has their own set of rules pursuant to their state constitution. Utah Rules of Criminal Procedure, rule number 13, pretrial conference, 13A. The accused shall be present unless he waives his right to appear. So once again, it's a right to appear, not a requirement, and you can simply send them a letter saying, I hereby waive my right to appear. You have to have the court heading and caption, and it has to be a legitimate court form or they will not accept it, but that is simply what you would do. So now let's say they set the matter for trial, and you received that notification in the mail, but you say to yourself, well, I don't want to fight it in the local court. These aren't courts of record. These judges aren't licensed attorneys. They never went to law school. They're just local court judges. They'll just ignore the Constitution, they'll ignore my rights, and they'll just find me guilty. I'd rather fight it in the higher court where I have a better chance of winning. If that is your attitude, which is the attitude of a lot of people in America who understand the system, in Utah, I will refer to the Utah Rules of Criminal Procedure, rule number 17, the trial, 17A. In all cases, the defendant shall have the right to appear and defend in person and by counsel. The defendant shall be personally present at trial with the following exceptions. 17A1. In prosecutions of misdemeanors and infractions, defendant may consent in writing to trial in his absence. So there you have it. You can appear in writing and consent to trial in your absence. A lot of people would rather fight it. I understand from personal experience here in the state of Utah, these judges are incompetent. Most of them never went to law school. Most of them aren't lawyers. And the ones who are lawyers, I did my research and found out they're all former city prosecutors. So they're all on the same team. They all work for each other and with each other to find reasons to convict you. It's never you versus the prosecutor in a justice or traffic court. It's you versus the judge, a biased judge, and the prosecutor inside of a revenue-raising court, and that is the truth of the matter. Now you can learn how to file these appearance and writings yourself pursuant to your rules of civil or criminal procedure. Or, I'm just putting this out there for a small fee, I do offer a nationwide service at leonaslawllc.com, an appearance in writing to the initial appearance, the arraignment, the pretrial, and the trial, and even appearance in writing to file your notice of appeal. You never have to personally go to the courthouse when receiving a traffic ticket. And even if you don't want to fight it, it's recommended that you appear in writing and plead not guilty so that you don't have to waste your time going down there, and then you can show up at the pretrial and negotiate your plea in abeyance. However, that concludes today's video. If you'd like to learn more information like this, I ask that you subscribe at youtube.com/LeonasLaw and like the video. And if you would like to show your support, I ask that you go to facebook.com/LeonasLaw and like my page. And with that being said, I'd like to thank you for watching. Once again, this is Jacob Culliton from Leonas Law at leonaslawllc.com.